Court calls the cases of the People versus Matthew Fitzgerald. Two cases.
Absolutely, for the people of both matters.
Ready, Judge.
This courtroom opens with pure procedural chaos, wrapped in calm politeness. Judge Simpson doesn't waste time, and right away, defense attorney Robert Ellman starts explaining why his client isn't even present. That's already a red flag. Missing court rarely goes well, but Ellman's confidence says he's walking a tightrope with balance. As he explains that his client, Matthew Fitzgerald, is in another county's custody, the tension rises. Viewers, take note. This happens when defendants juggle multiple cases across jurisdictions. It's like trying to play chess on two boards at once. One wrong move and both games collapse. Simpson's tone remains measured but edged with skepticism. Classic judicial restraint masking irritation. He's letting Ellman talk, but his mind's already on accountability. This opening exchange isn't just procedural. It's about responsibility, control, and whether excuses can hold up under pressure. The courtroom mood is civil, but the stakes are building fast.
Good afternoon, Your Honor. Robert Ellman on behalf of Mr. Fitzgerald.
Commercial Feaster, Assistant Public Defender, also on behalf of Mr. Fitzgerald, on file number ending 507.
Your Honor, Mr. Fitzgerald is not here. However,
Really?
there's a good reason for that,
Oh,
and I'd love to share that with you.
okay. Go ahead.
So Mr. Fitzgerald has a case in Livonia, and as you recall, due to a bond violation, you placed him in custody. During that time while he was in custody,
I
he had.
did.
Yeah, I'm just trying to make the record
That
clear.
you sounded accusatory, but go.
No. I'm not accusing you of
No,
anything. Your
no,
Honor.
no, I get thick skin. Go ahead, Mr. O.
Well, while he was in custody, he was scheduled for his sentencing in Livonia, which he then missed. So they issued a warrant. He turned himself in on that warrant, and they did immediate sentencing, and he is currently in custody because they sentenced him to 10 days in jail. So that is why he is not here.
So, did you hear Elman's whole story? So Elman's whole story is, Judge, you tipped the first domino.
No, Your Honor.
That started this whole thing on the. Yes, that's exactly what you were saying.
That moment? Pure courtroom comedy. Simpson humorously flips the narrative, suggesting Ellman's whole defense story basically blames the judge for setting off the first domino. That level of sarcasm from a judge tells you one thing. He's aware of every game defense attorneys try to play, yet he delivers it with charisma, not contempt. This is part of what makes Simpson stand out. His mix of authority and humor keeps the courtroom human. The back and forth shows mutual respect disguised as verbal sparring. Notice how Ellman quickly recovers, staying courteous while trying to secure an adjournment. He knows humor from the bench can diffuse tension, but it also signals the judge's patience is limited. Judges often use this tactic to balance discipline with levity, reminding everyone that beneath the jokes, real accountability still rules the room. Who do you think handled that better? Ellman's diplomacy or Simpson's wit?
That's why Feaster is standing awake.
Well, Your Honor, he is in custody, and
Feaster
so
has
therefore
come
he's
nowhere
not
near the
here.
podium. Feaster like looking at you like, go ahead, you say it, man.
Have I mentioned how good it is to see you again, Your Honor?
Probably should have led with that. All right. So you're seeking an adjournment.
If the court would be so kind.
Well, Mr. Feaster, are you seeking an adjournment?
Yes, please.
Then that I'll grant. All right. Probable cause conference on both of these cases, May 22nd, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Thank you, Judge.
Thank you, Your Honor. 22nd.
Feaster smart. Feaster said, I am not kidding. Court calls the case, People versus William Phillips.
Here's where the courtroom resets, but not for long. As William Phillips takes the stand, Judge Simpson's tone shifts from casual humor to focused authority. Ellman returns as defense again, his second client of the day. That's important. Same lawyer, different case, same pressure. You can feel Simpson's eyes saying, "Don't test me twice," in one session. Phillips looks uneasy, distancing himself verbally. "I'm not with him." That quick quip hides anxiety. Defendants often try humor to mask fear, but Simpson's sharp presence ensures no one forgets the seriousness of what's happening. We're about to hear about bond, discovery, and a sensitive domestic case involving a pregnant partner. That shift from light banter to human reality is why courtroom footage hits so hard. It's unscripted morality in real time. Watch closely. You're about to see how legal arguments mix emotion, logic, and consequences in under 2 minutes.
And is it on behalf of the people?
Good afternoon again, Your Honor.
Oh, no, he's back.
Again, always great to see you. Robert Ellman with and on behalf of Mr. Phillips. Mr. Phillips, can you please state your name for the record?
William Phillips. Mr. Phillips is like, I'm not with him. No, go ahead. All right, what are we doing?
Your Honor, I was just appointed on this matter. I would be asking for an adjournment for time to get discovery. However, I'd also like to address bond whenever you would like to hear that from me.
Like to hear that. I'll adjourn this to May 22nd, 2025, 9 a.m. Yes, that's the bond, Mr. Earl.
Thank you, Your Honor. I would be requesting a change in the bond order to a no non-consensual contact. It's my understanding that the complaining witness in this matter has shared that request with the victim's advocate's office. And again, as you know, that would put the ball in her court as to whether to have contact with Mr. Phillips or not. So that's what we'd be requesting.
This moment captures a critical legal nuance. The defense is asking for a modification to allow contact between Phillips and the alleged victim, but with consent. That's what no non-consensual contact means. It shifts power back to the victim, giving her control instead of an automatic barrier. However, the prosecutor immediately objects, highlighting the seriousness of the charge, strangulation. Judges tread carefully here because modifying such bonds too soon can lead to risk. Judge Simpson's refusal later shows caution and precedent. He wants to hear directly from the person affected, not through third-party reports. That's how accountability works. This wasn't about emotion. It was about procedure protecting potential victims. For viewers, what would you do as a judge here? Show compassion for co-parents or maintain strict safety. The balance between empathy and enforcement defines real courtroom power.
Okay.
I would also state that when did she do?
June 8th.
She's pregnant and due June 8th, and they do, how many other kids? Two?
Two.
They have 2 other children at home, so.
Your Honor, at this point, I would object. She did mention that to our victim advocate, and that was not, however, I just have concerns given the facts in this case and that strangulation. I think it's something that should be addressed at exam, or potentially in the future, but I don't believe it's appropriate to change that, provision at this point.
And if I could just add, Your Honor, this is, an older case. So they've been, to my knowledge, prior to the charges being filed, successfully cohabitating since the date of offense without any issues.
All right. I am disinclined to change that. I typically want to hear myself from anyone wishing to change the bond, even though they may communicate it. I then want to hear the people's sort of feelings on that, but I would need to hear from the individual themselves.
This single sentence is judicial discipline in action. Simpson recenters control, reminding everyone that the court's decisions hinge on first-hand voices, not assumptions. In domestic cases, especially those involving violence or co-parenting, judges know one misstep can have devastating effects. He doesn't rush compassion, he insists on verification. Notice Ellman's calm acknowledgement. He's seasoned enough to accept the denial without pushing harder. He knows over-arguing risks credibility. Then comes Simpson's classic humor again, joking about apparently looking like he cared. That mix of seriousness and dry wit keeps the tension manageable while reinforcing hierarchy. This is courtroom management at its finest. Simpson balances humanity with authority. He listens, corrects, and controls the rhythm of proceedings. The audience laughs, but beneath it, everyone understands. The courtroom isn't therapy, it's structured accountability.
Thank you, Your Honor.
All right, so motion for bond reduction at this time is denied.
Thank you, Your Honor.
Thank you.
All right, you're all set.
Thanks.
And that's it for me, Your Honor. You don't have to deal with me anymore today.
Okay, so apparently on my face, it looked like I cared. No, okay, I'm sorry. I'm sorry, that was so wrong, Mr. Elman. Thank you, Mr. Elman, always a pleasure, sir. I know, that was. I feel bad now. What? Take it back. Court calls case People versus Jody Merritt.
People,
Or Yagi, Assistant Public Defender, apologies, with and on behalf of Ms. Merritt. Your Honor, may we approach in this matter?
Pardon?
May we approach in this matter?
Yes, you may.
Did you tell me that it was non-consumption, consumption? The people said non-consumption. It detected alcohol, but it was non-consumption. It was one of the things.
Now the energy changes completely. The Merritt case enters, bringing addiction, relapse, and accountability to the forefront. Defense counsel approaches the bench quietly. It's sensitive. Alcohol violations tied to SCRAM tethers, ankle monitors that detect alcohol through sweat, are serious. Here, the reading shows tampering, and that's nearly impossible to explain away. Her attorney argues medical issues and genuine effort, AA meetings, outpatient setup, documentation. On paper, she's doing everything right, but the prosecution presents a brutal contrast, a 21-hour tamper with alcohol detected while out on bond for an OWI operating while intoxicated. That's devastating for credibility. Judge Simpson listens carefully but leans on public safety. Sobriety violations on restrictive bonds leave judges little room for leniency. Viewers often underestimate how precise these decisions are. They balance fairness against risk to the public. Merritt's intent matters less than verified results. Would you have believed her defense or sided with the data?
Go ahead.
Your Honor, I know I made arguments at the bench regarding my client's medical issues and her all of the things she's done to stay sober. Specifically within the last couple of weeks, she's gone to AA meetings almost every day. She keeps a log. She has verified signatures. She set up an appointment for intensive outpatient. She, I know I said this at the bench, but just to reiterate for my client's benefit, she called down firms. They told her she was not eligible for inpatient. She has medical issues, which I won't go into detail on the record, but I did at the bench. And we were asking the court to consider continuing her bond prior to the bond violation hearing, which we are requesting at this. We would request that it be set for a bond violation hearing.
in your honor, as I indicated at the bench, previously we had accepted an offer in this case. That offer at this time is revoked. The defendant does not have a current plea offer. It may be made again at a later time, but right now it has been revoked. The offer in WI second with sobriety or recovery court. The issue here is that the SCRAM tether does seem to confirm a 21-hour long tamper with alcohol detected. So people have concerns for the general safety of the public, as this defendant is currently on bond for a operating while intoxicated third offense with an alleged BAC of 0.17. I think it's 171 on the blood draw. And the risk that comes to the public, if this is a person that is on the most restrictive bond condition we can impose for alcohol, other than incarceration, who has an alleged tamper with that SCRAM, there's too much to ignore, and I am requesting the defendant be remanded at this time.
Court, having listened to argument and having examined the alleged bond violation in this case, does find that it's significant with reference to the tamper to the device with alcohol detected. And for those reasons, and the court, on seeing it initially, issued a bench warrant with no bond. At this time, the defendant's bond, the court is going to order the defendant's bond is revoked. And I will set a bond violation hearing as well as her PCC.
And there it is, the hammer drop. Judge Simpson revokes Merritt's bond, sending a clear message. Compliance isn't negotiable. When you're on bond for an alcohol-related charge, a tamper alert is fatal. This isn't cruelty, it's consistency. Courts depend on reliability. Defendants must prove responsibility through action, not promises. Merritt's case reveals a harsh truth about recovery in the legal system. Intentions don't outweigh evidence. The judge's reasoning is methodical, citing public safety and prior warnings. In his courtroom, every violation is a data point, not a debate. That's how justice stays impartial. Still, the emotion lingers. Defense counsel's frustration merits silence, the audience's discomfort. It's the cost of a system where compassion and consequence constantly collide. If you were sitting on that bench, would you prioritize redemption or protection?
For May 15th, 2025 at 3 p.m. Defendant is remanded. Court calls the case People versus Stephen Watson.
And then on behalf of the people, Your Honor.
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Watson, Your Honor. Mr. Watson, state your name for the record.
Stephen Watson.
Go ahead.
Your Honor, I have had a chance to go over this matter with Mr. Watson. We're asking the court to set a preliminary examination.
All right, I will set a preliminary examination, but he has a bond violation in court.
Yes, we're aware of that, Judge.
All right.
Your Honor, I did receive the report and have gone over it.
Does he have a prescription for that?
Your Honor, he did send I believe he tested positive last week. He did pay to have that sample sent to the for confirmation or not. They're waiting on that. Today is his day to test. Mr. Watson has indicated that he will that it will be negative.
For what?
Everything except for, I believe he has a medical marijuana card, Judge. I'd ask the court to allow him to run over there and test past this matter. And
Yeah, I haven't, since the end of March, I had cocaine, amphetamines, THC. Amphetamines, THC, and then that was on the 10th, and then on the 14th, I got cocaine again. I have amphetamines then and THC into his system, but he's not reporting any medication that's gonna show as an amphetamine.
Your Honor.
Yes.
Also concerns that he missed intake on 4/28 as well.
Yes, I've been working 12 hours, 7 days a week. The community corrections lady told me to come to court, see if you allow me to come and drop. That way they can reassess me and get me back in. But if I drop today, I drop completely clean, everything. And, I'm trying not to lose my job. I've been at the same job for a year and a half. I've been staying out the way. I can go drop, come back, and everything will come back clean, Your Honor.
Your Honor, he is working at Marsh Plating.
Is he saying that, does he want a hearing on this? I don't know what else.
Yes, because I'm trying to stay out of jail, trying to keep.
I know you're trying, well, everybody is, but
I just want to be able to go drop, come back, so I can be able to maintain my job and get reassessed. The lady at community corrections said I can get reassessed into a program, outpatient program, if need be.
why is the amphetamine showing up in your system?
That part, I'm not sure. It could have been from some over-the-counter meds or anything, but I haven't used. I've been working every day. Like, that's all I do is work from 3 in the afternoon to 3 in the morning. I'm on my hours. I just asked the court to allow me to go drop to prove that.
You have all of the discovery, mister.
Your Honor, we do have the discovery, yes.
I'm just
People had their witnesses available the 13th.
We'll do our best, Your Honor.
So is he not admitting to this violation, but?
Your Honor, in terms of the amphetamines, he is not admitting to them. In terms of the cocaine, I believe the initial test was positive for cocaine. There was a subsequent one. He did not have the funds. He was not working to the extent that he is now. He didn't have the funds to test it. I don't know if he wants to, you want to hear
No,
it?
that's okay. Well, I'll just we'll set his preliminary examination in person, May 13th, 2025, 9 a.m. That's before me.
If I could elaborate on bond, Judge.
Sure.
Your Honor, he is not a flight risk. He lives, he's residing over on East Forest, which is, probably 2 miles from here, in Ipsy. I don't think there's been any, well, we're here on a violation, but there hasn't been any violation alleged contact wise or anything like that. He is gainfully employed. I'd ask the court to allow him an opportunity to test. He has indicated to me that they would, if the court would allow, they would welcome him in for another chance to interview for the community corrections outpatient program. But
If I did drop today, I would drop clean, no amphetamine, so nothing.
I'll set a bond violation hearing at that same time, at the time of the preliminary examination, March 13, 2025, 9 a.m.
We've just witnessed Judge Simpson navigate multiple defendants, each case a different struggle, missed hearings, family complications, addiction, employment, survival. Through all of it, his courtroom tone stays consistent, direct, disciplined, and quietly human. He gives humor where it diffuses tension, firmness where safety demands it, and patience where effort is visible. From Fitzgerald's absent appearance to Merritt's bond revocation, these moments reveal the full emotional range of justice, order, consequence, and fleeting mercy. Viewers often see the robe but forget the balance behind it. Judges don't just issue rulings, they mediate chaos with structure. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns on Trial Truth.